and good afternoon, everybody. Timely topic in a sense that a little over a week ago, the FTC announced a rule regarding online reviews, and that does have some effect on social media influencers in particular, and the FTC's approach to false reviews and suppressed reviews and disclosure requirements when talking about uh, products and services online. Interesting, just as a side note, there's been a lot of reporting about, with the upcoming election, and the role of influencers in the election and campaigns allegedly paying influencers. And I wonder how the FTC would look at that. But in any event, that's not exactly our topic for today, but we will talk about that rule. I'll pull it up. This is a good, I really have done similar webinars and seminars of this with this topic in the past. It's usually, there's a few hot button issues. One thing we'll talk about is reputation and online reviews that you receive that ties into to the social aspect of what we're talking about. And that's usually a hot button topic because there's some folks who have had experiences with anonymous reviews or with negative reviews and problems that the immediacy and the widespread ability to communicate with a broad swath of people by just posting something online, and how that can really affect people's careers and businesses and so forth. So we'll spend some time on that. If you have any questions along the way, please fire those into the chat and let us know, or follow up with me afterwards. This is something that I get comments on and get calls with clients and with prospective clients on a regular basis. So the material may seem a little bit dry, but when you talk about it in discussion format, it really does bring up some interesting aspects. So here's our agenda of what we're going to cover. Again, broadly, the written materials are here for a guideline. What you're going to find is that some of what's available out there in the more formal aspect, particularly when we're talking about regulatory and institutional guidelines, I'll show you what the AMA's Code of Ethics says on social media. In my view, it's shockingly vanilla and unhelpful. Where we get some ideas and experience, maybe because social media and because the internet and communication is still a relatively new function, even though it seems like it's been around for a while. The law and both legal concerns, regulatory concerns, ethical concerns, business concerns, marketing, and so forth are all still getting used to how to adapt to some of the issues that we see. And so case studies and hypotheticals can be of particularly good use. And so we'll talk about that as well as we walk through the agenda, or walk through each of these topics. So when we talk about social media, of course, you've got the platforms that everybody's familiar with, Facebook and Twitter and Instagram, YouTube. Some of these are, we have LinkedIn on here. Some are more business oriented, some are more socially oriented. Me personally, I'm particularly fond of YouTube, and I find it to be a wonderful area, wonderful resource for learning about new topics and getting background on new topics. But again, you've got to be careful with the information you find on there, because there's very few filters in these areas. And so it allows anybody to go on and post almost anything, and that can be good and bad, and it can be detrimental, especially for professionals for career purposes. There's also specialized platforms. A couple of them listed on here: Patients Like Me, Health Unlocked. There's some other platforms. This started probably with, I think the original online health platform was WebMD, where people would go on and post comments and discussion boards and get feedback from professionals and from laypersons on health issues and other related topics. Again, it could be a valuable source of information, and it can be dangerous at the same time. There's another one that I wrote about, and I can't even remember the name of it, but it's a website that was government created, essentially, though, as akin to a social media platform for physician and prescribing providers to use for off-label use of prescription drugs. and how they had used those effectively, and essentially provided a discussion format for professionals to use that. So some of these are platforms for professionals. We're going to talk about all of these. The big challenge that we're going to see, the theme that you're going to see repeated is the widespread visibility of social media and the ability for professionals in particular, healthcare professionals, and this applies even to lawyers and to other professionals, to separate their personal and professional lives and the limitations that we see there. You also have the permanency and the immediacy that are of concern, and something that we always have to be aware of. So I talked a little bit about WebMD and the history, and this slide just provides the information of how we arrived at where we are today. Initially, most information that came from healthcare providers to patients and those trying to learn information was either provided in person during appointments and meetings, and it was one way, articles, information that was just published and broadcast. But social media, of course, opens up the opportunity to have a discussion involving two-way and group discussions, and of course that raises concerns regarding confidentiality and privacy and so forth. My mouse is giving me issues, so I'm going to switch and go to the keyboard here. I apologize here. There's a glitch on the screen. In modern healthcare, of course, we use social media for communicating with prospective clients and patients. It can be used as a platform for exchanging information. It can be used for professional networking. And again, the challenges that we're going to walk through here will be clearer, and probably either through personal experiences that you have had, or some of the case studies and the issues that we'll talk about. And really, again, we have the same thing as lawyers. It's this division or this blurring of boundaries between your professional life and your social life. And you realize that once you're involved in social media, if you're posting or if you have somebody posting for you, that area becomes grayer and grayer. It used to be, at least initially from my perspective, you had platforms that were more business related, more social related. But now, Facebook, which was to me the original social media platform where everybody could communicate with everybody and use it mostly with friends and family and so forth. That's a place where a lot of businesses set up their online business. There's a lot of marketing and advertising on Facebook, as well as LinkedIn, and businesses have a strong presence. And the reason why, in part, is because if you've ever looked at how you advertise on Facebook, there's an ability, a strong ability to target your information to specific populations. Well, how does that happen? That happens because of all the data that's available. And whenever we're talking about healthcare and that overlap between healthcare and communication online platforms, we have to be concerned with confidentiality and privacy issues that are prevalent with all of our communication. When we talk about privacy and confidentiality, the distinction as I see it, and this is my view of this, as I view privacy as a right that folks have. It's a right of control over your own personal information, how that information is disseminated and shared, and it's a personal right that is recognized through legal authority and is protected through obligations for providers and others to keep that information confidential. Confidentiality is a duty and privacy is a right. When we're talking about the rights of third parties, particularly patients and potential patients, when healthcare providers are communicating on social media platforms or similar type online environments, we want to be sure that the patients, if their information is being discussed, informed consent, just like with treatment, informed consent becomes the overarching principle. We want to make sure that anyone whose information is discussed online is fully aware of the limits and the ways that their information will be communicated, and is also aware of whatever security protocols, privacy protocols, and how that information will be shared. That means, of course, that any providers who are talking about this online, this has become more common as well, with folks posting stuff on online platforms, even before and after surgeries and so forth. How secure is that platform? How is that information treated? What does the provider do with the information? Do they share it? Do they make that information available? Is the information anonymized? You'll hear that term. Of course, we hear that in the healthcare context with HIPAA data, and how that information is anonymized for release. Just one interesting statistic to throw at you as far as anonymization goes. Now, HIPAA has specific requirements for anonymization, but you'll see a lot of websites and platforms that say, well, we're using anonymized data. We've stripped out information, or maybe you share information and you think you've anonymized the data. And I want you to give one statistic a thought. In the average zip code in the United States, if I tell you zip code and date of birth of a person, and give you whether that person is male or female, you're going to be able to narrow that person down to about 2 to 4 people in the entire zip code. That comes as a shock to a lot of people, but that's basically how the statistics work out. With very few data points, it becomes easier and easier, and especially now in the era of big data and artificial intelligence, becomes easier to unmask those individuals whose data is supposedly anonymized. All of this is under the overarching concern of privacy, confidentiality, and patient trust and integrity. And that comes back to the role of the provider whenever you have availability of information and data about patients that's private and confidential to them, your duty to keep that information secure. That's a big aspect of what we'll talk about and what we'll continue to talk about today. We're also going to talk about your role as you navigate the online world. So best practices for protecting confidential information of patients. Ideally, you avoid discussing anything about patient cases online. Sometimes people speak in broad terms. Again, we have the same obligation as lawyers, but the easiest way to get yourself in trouble is to overextend information, to overstep and provide information that you shouldn't make available. Again, I've mentioned the caution about anonymized data, and there are specific, and we'll talk about some of these, there's specific guidelines from the AMA and from other authorities with regard to the treatment of information and patient information and potentially private information of individuals. They provide pretty broad overarching principles, but when you dig into the information, you have specific cases, you really have to take a lot of this information on a case-by-case basis. And in that regard, I always think that you err on the side of caution. You err on the side of not disclosing information. If you are on a platform and you're not sure how that information is used, and that's most large social media platforms, if you're not sure how that information is secured and you're not sure how the information is used, you want to consider another platform or maybe avoid it. There are some cases we'll look at here, and I want to jump ahead to those in a minute, of information shared in forums that were supposed to be closed forums on certain online platforms, but a closed forum depends upon the control measures and security measures that are used to keep that information or that forum closed to those particular participants. Is it really a closed forum if there's thousands of individuals that are involved in that discussion? And who controls that information? If you don't have control over it, how do you know that the information that's shared in an online platform isn't going to be shared or disclosed either in violation of the patient's rights and in violation of the trust that that person has in you, or disclosed in a way that maybe you don't have knowledge of it, but later is in a way that's aggregated with other data that can be used in a harmful manner. We saw that a little bit with some of the issues that came up, public issues around the time of COVID, where large data sets were improperly manipulated and used by, or purportedly improperly used and manipulated by large companies to influence behavioral decisions. You know, obviously the vaccine is a hot button topic for a lot of folks. And this is an area that healthcare providers should at least have some background and be cognizant of if you are using these online platforms, which almost everybody is. But I want to also bring your attention here to the slide where we're talking about fitness trackers, medical devices that are tied into technologies that communicate with healthcare providers and communicate with online websites and communicate health data. That information becomes integrated with social media platforms and can be shared. And sometimes people just they have some they go for a run or they have some exercise watch or fitness tracker, and they share that information online. No big deal. But what other information is that tool sharing? Is it sharing other health data that folks aren't particularly aware of? Is that fitness tracker or watch or something else? Is it tracking people's movements in a way that are not fully disclosed? And if you have patients using these tools, and you're advocating for the use of these tools or communicating with them while they're using these, relying on the information that these tools provide, that's something that you want to make sure that if you're involved in that directly and you're guiding folks or advising folks to use these, again, come back to informed consent. Understand, exactly what you're using, what's the purpose of the information that's going to be gathered, what's the limits of the information that's going to be gathered, and be cognizant of the fact that if you don't control that information yourself, or if you don't have direct communication or direct contact, it's not something controlled by your company or your employer or somewhere where you have access to the top person essentially who's controlling this data, you really have no control over. And this is another opportunity where things that seem like they have a lot of benefit, which they potentially do, glucose monitors and heart monitors, that have a lot of potential benefits for health purposes, can be misused and manipulated in ways that are, again, it comes back to a fundamental violation of patient rights and of individual rights. You may think, well, that's not such a big deal. What's the worst thing that can happen? Well, if you go back and you look at some lawsuits, you'll see that companies that have either been hit by the FTC for patient violations, and this is just on general sharing of information on online platforms. They've been hit by lawsuits for violating patient or individual rights. It doesn't have to be patients, it can just be individual rights, by violating individual rights, by disclosing more information than what was put in their privacy disclosures. And there's a lot of opportunity for abuse, especially now we have, of course, artificial intelligence, the rise of ChatGPT. All of this stuff relies upon the aggregation of large quantities of data. The data points create patterns and create this ability for a ChatGPT or another artificial intelligence tool to predict behaviors, predict outcomes in a way that makes it seem like ChatGPT is a sentient being. It's another person that's able to answer questions really fast. It's really just working off of large data sets. Where is the data coming from? Well, obviously the internet gives us huge swaths of data, but how is Facebook, how are some of these other individual platforms able to target their advertising so well that make them very profitable and very effective vehicles for your advertising? Well, this happens because of the data that's gathered through all these different tools. All right, so with that background, let's jump into some examples here. So one example, a case, and I've anonymized this information. Some of this may sound familiar if any of you read on this stuff or follow it. Sometimes you just see this in the news or you'll see a lawsuit. Most of these are not lawsuits. These are just cases that I was able to find. So a nurse working in a rural hospital sent out a tweet complaining about the hospital's capacity issues and ability to care for these patients, essentially raising issues regarding underfunding and lack of support for patient care. And so the nurse was putting this out on Twitter. And of course, the hospital did not like being shown in this negative light in an online platform. And so there's these balance of concerns between the ethical concern of patient care and the hospital's concerns about the view of professionalism of the staff, the view of the hospital itself, and ultimately the hospital in this circumstance reprimanded this employee. From what I can tell, the nurse kept her job, but received a reprimand. And ultimately, the question is, how favorable is the fact that how favorable is the use of social media in this circumstance? Is this something that should be punished? Is this something that should be questioned? Like, why does somebody have to go to a social media platform to raise awareness of patient care issues? Is this a last act of desperation, or is this something that that is really just inappropriate behavior, an employee complaining in a platform that they have the ability to complain on that 5 years ago, or 10 years ago, or maybe longer didn't exist? Difficult issues. And some, especially if you're an administrator or you're an employer and you're dealing with something similar, what lessons do you learn from this? How do you avoid something like this happening to your practice? One is, I recommend that for provider practices that I represent, I recommend you have a social media policy. Consider the business's social media accounts anywhere where you post online. If you have anybody posting on behalf of your practice, they should be specifically authorized. I normally include this in an employee handbook. I have a social media policy that I write for clients. I make the clients, or have the clients' employees acknowledge that any social media that they have access to for the business belongs to the business. These are business assets: your Facebook account, your LinkedIn, your if you have Instagram or YouTube, any other account where you post information. If you run discussion groups on any of these are all assets of your business, and you need to treat them as assets and make sure that the employees recognize that and recognize the limits of what they're able to discuss online about the business. It's very, very important if you have employees that you have some type of policy so that they know what they can post or write about and what they can't. Very often, all too often, I receive calls from clients about, or used to, it doesn't happen as much anymore, but it used to happen a lot, where clients would call me and be concerned about posts that an employee or a former employee put on social media and want to know if there's anything they can do about it. Well, if we have a written policy in place, it makes it a lot easier to take some type of action, because the employee has now violated that policy, potentially violated confidentiality rules, depending on how the treatment of that information. A policy gives us ability to have recourse and potentially have this stuff taken down. All right, next one is okay. This is an interesting one. A physician created a Facebook group, and it's private. I don't do a lot with groups on Facebook, but I know you can create private groups or open groups, and in the private groups you have to be invited. Created this private group for certain patients who had chronic illnesses to share information with each other. And what happened is the information was being shared was too private, or it was too much information from the patients in a forum that was purportedly private, but really wasn't. And the concern was potential leaks of that information. People who were invited to the group, again, a group of 40 people that where they all come from, and they've all been vetted, is one thing. A group of 400 people, very tough to keep it entirely confidential. How much of the information, and another concern is there's other folks who can get access to somebody's social media accounts. A lot of concerns with posting very private information in a forum like that. So there was a concern about the sharing of that information becoming too widespread, and what ultimately the remedy was that this group came up with was to create a separate discussion forum in a secure platform off of Facebook, but in another environment that was controlled, in a server that they controlled, and create that private forum and then have a password protected, and make sure that they vet all the individuals who are allowed into that platform. Again, the other piece of this is, one, it's up to the patients if they want to participate in this. But if you tell folks that they have a secure platform, or they're going to be invited to a private group, and there's concerns that it's not really private, that's going to create issues for you. There's back to the informed consent. How much information, how honest are you being, and how much are you doing to treat the information as confidential, to protect the privacy of the individuals that you invite into this group, if you are in fact the person who sets up the group for these folks, or if you're inviting patients, or if you're advising folks to go to this group. Pardon me. So another concern with social media is crowdsourced information. People go on. This really started, I think, again, I mentioned WebMD earlier. People would go on to WebMD and ask questions and look for information, look for answers, when they start sharing information, and then they start getting advice from people who are not qualified to give that advice. That's a huge concern. If you have a group, it's not unusual, by the way, for providers or practices to set up these discussion groups. You need to make folks aware in some type of proactive manner, in the form of an informed consent, or as a policy. Perhaps it could be your terms and your privacy policy for the particular platform. You need to make folks aware of the fact that the information that they get is not medical information. They can't rely on that information. Anytime you're posting information online, you want to make sure people understand that's not medical information. You're just introducing a general discussion topic. Again, we have to do the same thing as lawyers. Make sure that people know the difference between a general discussion for a general intelligent discussion, and a discussion that involves professional advice, medical advice, legal advice, etc. Okay, so here's a couple hypotheticals. Imagine a hospital that implements an AI tool that monitors social media activity, detects signs of depression and suicidal thoughts, and flags posts that should raise concerns for the healthcare provider and alerts the provider. It sounds like it could potentially be a good idea, but think of all the other issues that come up. Again, how much are the patients aware of the information that is being shared with the providers? What is that information being used for, other than alert providers? What's the accuracy of the tool? What information is it relying upon? What are the chances that you could get false positives? What's the potential liability if you have some environment like this and people rely on it and it doesn't catch someone with suicidal thoughts before it's too late to step in and make a correction? A lot of ethical issues. Candidly, we don't really have the answers. These are the types of questions that come up, but the idea is just to make you think about issues that can arise whenever you're engaging in group discussion or group behavior online. This is another interesting one. I've read a little bit about these virtual reality therapy sessions, and some of them that can be, creating a very real environment for patients. But sometimes people can find that disconcerting. Depending on how real the environment is, what's your duty if you have somebody, a patient or someone that you're advising, and you send them into one of these environments? What's your duty to make sure that they understand fully the emotional impact of the sessions that they might engage in? You need to think about this. You also need to think about what information is gathered through these virtual reality environments, what information is captured, how is that information stored and used, all the same HIPAA concerns, because if somebody's going into this environment for therapeutic purposes, they're likely sharing information that is going to be very private, very confidential information, and we need to think about how that information is going to be used. There's also a question here about equal access to care, to healthcare. If these sessions are effective, what's the expense and how accessible are they to the common person versus somebody who has the additional funds available to pay for these sessions? That's always a concern, but especially becomes a concern when we're talking about more technologies, such as artificial intelligence technologies and virtual reality for healthcare purposes. And here's another one. This kind of ties into the FTC, some of the FTC rules. And I've seen this. There's some folks on YouTube that seem very educated and provide some valuable information, but they're selling a product, or I suspect that they're selling a product. If you're on a social media platform and you are being paid as an endorser for a product, or if you are making money through referrals for products or for services, that needs to be disclosed. The FTC, prior to the recent rule that was passed, the FTC for the past several years has had a set of guidelines for social media influencers and for paid affiliates, and the duty and the requirement to disclose information so that folks understand that when you make recommendations or when you're providing information online, that's purportedly for the benefit of the general consuming public. If you're making money by referring a product or a service, you need to disclose that, and you need to disclose it in a meaningful way. And then, of course, we just had the rule that came out on reviews, and the FTC talks about what a meaningful disclosure is. So if anytime you have a situation where you're providing content that is held out to be educational content, but that content is designed to help sell a product or a service, you need to disclose that when the link exists. Now, of course, we do seminars in our office every month. Several folks have maybe a YouTube channel or some other platform where they educate others, and that might drive business to them. It may drive individuals to seek them out for further business. That's not really what is contemplated by the disclosure requirements. This is more a situation where, for instance, this is something that I saw recently, if you are a medical provider and you have a channel and you're talking about therapeutic massage chairs, and you are giving reviews on therapeutic massage chairs, and you say, this is the particular one that I recommend, and here's a link where you can go buy the chair, and if you put in this code with my name, you get 10% off. Well, chances are that that's an affiliate link, and the person who's making that recommendation is getting paid for that link. It's actually, I've suggested this to clients who have particular health products that aren't prescription products, they aren't regulated products, but they're health products they believe in. I'm a big proponent of using supplements for the right purpose. If you're selling a supplement, or if you're directing people to buy a supplement that you believe in and you're able to make money off that, great. You just need to disclose it. There's no issue, there's no conflict of interest with simply making a profit off of a product that you sell or refer others to buy. You just have to make sure that that's properly disclosed. That's the general rule. Just like informed consent to patients, your duty to the general public is that whenever you have a situation where you're making money off of the information you're providing, you need to disclose it. We come back to, from some of the hypotheticals and case studies, the overarching theme here is the importance of clear policies, abiding by ethical guidelines, full disclosure, informed consent, protecting patient trust, the integrity between the provider and the public, the provider's professional role and the role of the public, privacy, confidentiality, duty to allow folks to have their information or private information kept confidential, also maintaining clear delineations as much as possible between personal and professional online personas. That's becoming more and more difficult, but it's still a good idea to always say, I'm not acting in a professional capacity. This is just my personal opinion. Sometimes you're in an environment with employers and larger medical groups or hospital systems or government agencies where you're required to say that this isn't the opinion of the agency that I work for. This is my own personal opinion. As much as you can maintain that boundary, but while doing that, always remember that folks are still looking at you as a professional, someone who they rely upon for educated advice. All right, so the AMA publishes some guidelines, Federation of State Medical Boards publish guidelines. So I'm talking about some of this material, and I go to the case studies and say, well, what do the rules say? I do the same thing with lawyers. You know, you look and you say, okay, well, what do the rules say? Well, I'm going to pull up on another screen here. Here's the AMA Code of Ethics. And this is professionalism and the use of social media, 2.3.2. And it talks about social media and the value and all the stuff that we've talked about generally, integrity of the patient-physician relationship. And I'll scroll down here, and this is in the materials that you should have. Physicians and medical students should, when publishing content, consider that even personal social media posts have the potential to damage their professional reputation or even impugn the integrity of profession. There's a bunch of statements here of general overarching principles when it comes to social media. Candidly, I don't find this is sort of common sense stuff if you're a professional. I don't find it particularly helpful. What's helpful is looking at specific circumstances and then trying to figure out, okay, under these specific circumstances, what's the best course of action? So with that said, I'm going to skip past. I just want you to be aware that there's some guidelines out there, and if you are a member of any particular, again, if you're a member, if you're a physician, if you are another professional group that has its own regulatory body, there's probably some information that you should take a look at. Some are better than others. Some are more useful. Sometimes there'll be rules or case studies with particular information. But sometimes you just got to take this stuff on a case-by-case basis. And in the meantime, use your best common sense. Managing online reviews. All right, so this is a hot button topic, online reviews. I'm going to pull up, the FTC just passed this rule, and I want people to be aware of this because we're going to talk about online reviews. And but let me go through a couple more slides here. We'll get to the online reviews. I'm going to show you the FTC rule. So you want to obviously encourage positive online reviews, and you'll have situations sometimes in your career where you have to deal with some type of negative review online. Keep in mind that you have HIPAA considerations. You can't respond online and get in, even if a patient raises the issue first and says this professional screwed up this procedure, did this wrong. I have this happen a couple times a year where a client calls me and they have to deal with a complaint. Either to, I just dealt with one just the other day, to a regulatory agency, and which is almost better because at least that gives you an opportunity to respond, or a complaint to in an online forum, Facebook, Google reviews, one of these places. And the worst is when these things are anonymous. So, first, what I want you to do is consider that although this information is all private, you can ask your patients and ask folks that come to you for service, if they're happy with services, to leave a positive review. But you want those reviews to be general. You don't want any personal information discussed. Just, I visited with this professional. I just had a dentist appointment last week. I've had the same dentist myself for almost 20 years. I post a nice review online. They're prompt. They're super friendly. They get everything done that I need done. It's a very comfortable environment. I'm always very happy with the service. Obviously, I've been going there for 19 years. Very happy with the dentist. I'm happy to post a very general review. It doesn't mean I have to go into my own personal information. It's totally okay for you to send something even to patients or clients after you visit with them and ask them if they're happy with the service to post a review. That'll benefit you. Again, there's some guidelines on dealing with reviews. Not particularly helpful in my view. It's more common sense stuff. Always just abiding by the confidentiality requirements and don't lose your professionalism online. Don't argue with people online. Don't post fake reviews. When you're dealing with online issues, you want to be sure that you're monitoring. You have somebody who's monitoring with that. And you want to make sure that all of your online communication with patients, whenever you're posting anything or responding to anything, is positive. If you get a positive review, it's good to go on and respond and thank that person for posting a review. If you get a negative review, I suggest you go online and you just post, "We're sorry this experience happened, and this person, posted this in a public forum," and then try to reach out to that person privately. Every once in a while, you'll maybe have some success where there's a misunderstanding, and by you reaching out personally to somebody who leaves a negative review, that person goes back and revises the review or takes it down. May or may not happen. Some forums don't allow you to do that, but it's not unusual. And in my experience, the few times I've posted negative reviews on a business, I love giving reviews. I usually give positive reviews. If I've given a negative one, usually because I want to get the business's attention, and I've tried already by going directly to the business and it hasn't worked. And if I get a quick response, I'm happy to go on and make a revised review and update it. Say this business contacted me. I'm very happy with the outcome. Bedside manner matters. That's what I like to say on these. So I'm going to pull up this FTC rule. So this came out about a week ago, and I'm going to enlarge it here. The FTC talks about consumer reviews and testimonials. You can't have fake or false reviews. I'm going to walk you through what I think are some important things in this rule. We're not going to have time to cover the whole thing. This could probably be its own seminar. Definitions of several terms. Clear and conspicuous. This is the disclosure requirement whenever you're acting on behalf of a company or a service. If you're not totally independent and you're acting in a capacity as an influencer, you're trying to influence others to take some action, do anything, it needs to be clearly disclosed according to the FTC. This is what the FTC says. Again, raises interesting questions with the election that we have, whether paid influencers who are advocating for political purposes are disclosing the fact that they're being paid. Fake reviews, these are all defined terms. I'm going to scroll past these. Bear with me here because I'm going to come into the rules, and then from the rules you'll see why some of these are important. So what the FTC says, it's an unfair, deceptive act or practice. That's what the FTC is entitled to manage in our regulatory environment. Unfair, deceptive business and trade practices. It's an unfair, deceptive act or practice, the FTC says, to post false or fake customer reviews or testimonials. Purchasing reviews, there's been a lot of information about that. A lot of times you go on certain sites and you see several reviews, they're all around the same time frame. There's companies that used to sell reviews. The New York Attorney General several years ago went after a group that was doing fake reviews. Now the FTC has come out and said you can't have fake reviews. In addition to that, if you, again, unfair and deceptive practice to disseminate fake reviews. And by the way, the FTC also says, look at this rule right here. This is one of the things that the FTC doesn't like. If you procure reviews from officers, managers, employees, or agents, or any of their relatives, you say, hey, all of our employees, friends, and family, go on and post a good review about our practice, about our business. When you do that, you need to disclose in the review, if it's not already obvious, that you have a relationship with the business or the practice. If you are one of the employees of the business, but you believe in the mission of the business or the practice or whatever it's doing, it's perfectly fine for an employee or for a staff member to go online and say, having worked at such and such a medical practice for the last 5 years, I have great admiration for the providers and the way that the practice treats its patients. Everybody tries to do everything the right way. That's perfectly fine. But if you go on and you act like you're just a random customer on the street, if you have employees or if you're doing that for your own practice and you don't disclose that, the FTC says that can lead to problems. There's some exceptions. You can go ahead and make generalized solicitations to your own folks and to your customers and ask them to go post reviews. There's nothing wrong with that. So when my dentist sends me something and says, if you had a good experience, we'd love for you to post something online. That's fine. You can do that. You can't buy reviews. There's more information on insider reviews. These are managers, officers, owners of the company who post reviews and have it disclose their relationship with the company. If you're being paid or if you're being paid for your opinion or paid to offer advice about a product or service, or if you're paying an influencer, that needs to be disclosed. That person needs to disclose its relationship. And when we go further down into the rule, company controlled websites and entities. This is companies that there are some companies out there that do online reviews, but they actually are owned and controlled by a product. This was rampant in certain industries, mattress companies. I had a client, we had an issue with this a couple of years ago, where they owned a review company, had a large following doing reviews for other services, and then created a competing service product, service, and didn't disclose the relationship with their competing service and put it right on with these other services. They hadn't disclosed that. And what I found is that there's a whole history that goes back, and there was like the mattress wars, where these online, if you're shopping for a new mattress, you'll find all these review websites, and a lot of them are owned by the mattress companies. Or if they're not first owned by the mattress companies, they become acquired by them. That used to be what the situation was. I don't know if that's still the case. You see that in a lot of industries. You'll see products or services that are being touted online through a review website, and it turns out that it's really just the paid advertisement. Review suppression. I found this interesting. I had a client a few years ago who didn't like what a former employee said about them online on Facebook. And it was a post where the employee had taken a quote. The client had sent an email, a very obnoxious and rude email, in my opinion, to an employee, very degrading type communication. The employee took that email and posted it online. And the client says, I want you to get them to take it down. Well, it's your words. I don't know how I get them to take it down. It wasn't communicated in a confidential setting. This is just a random email that you sent this person. You don't have any requirements that the communications in the office stay confidential. No good way to legally and morally and ethically get this person to remove the post from Facebook, other than just trying to threaten them and bully them to do it. And the client was I lost the client. The client was insistent. The client was irate that I wouldn't send a cease and desist letter and threaten to sue this person for, make up whatever your cause of action is. Defamation is usually it. I would not do it. There was no basis for a cause of action for defamation, for taking somebody's own words and putting them online. But now the FTC, apparently this must be a thing, because the FTC felt it necessary to have in its rules language that says that you cannot legally do that. Let's see if there's anything else. Okay, there's the end of the FTC rule. Wanted you to see that and some of the points. If you have questions, maybe we'll do a seminar if it makes sense. We could talk about a little bit more about reputation management, because this comes up a lot with my clients, where issues come up with online reviews. Here's a case study. This is actually a case that I was familiar with. Again, I've anonymized a lot of this. Yelp. I'm not a big fan of the Yelp website, but people will go on there. They'll post their complaints on Yelp. I believe that the Yelp algorithm actually used to, I don't know if it does anymore because I don't go look at it, used to manipulate where the reviews, negative reviews and positive reviews, and then Yelp would sell a service that would help you improve your standing on Yelp. Well, what that service would do is would suppress the negative reviews and put them at the bottom and put all the positive reviews at the top. But if you didn't use the Yelp service, it would be flip-flopped, and somebody would want to look at your business and they would see negative reviews posted first. To me, that's manipulating the content in editorial fashion. It should expose Yelp to liability. That wasn't the case. They were sued over it, and from my understanding, nobody ever really got a good foothold on that lawsuit. But in this case, what the doctor did was thank the patient for leaving this feedback, reached out personally to that patient, and was actually able to get some candid discussion with the patient in a personal setting, not online, and then the review was revised online. So a good outcome from having a negative review. Here's another case where a dentist received a negative review from a patient, and sometimes people ask me, well, how do I respond to this? You don't want to respond. You certainly don't want to argue. That's the big mistake that folks make, is they want to go online and they want to argue with people who leave these reviews. That's a huge mistake in my view. Go online and just say, it's unfortunate this person chose to leave this review. We've reached out privately to remedy the situation. This is not common in our practice, or come up with some language that basically says this is an anomaly. Hopefully you have lots of positive reviews, and that's okay. You can balance the positive reviews. I encourage folks, especially if you have a negative review and you want to deal with that, best way to deal with that is to counterbalance it with 10 positive reviews. You have to be honest, but you can ask lots of people to leave reviews, counterbalance it. And then if you have one of these where you know who it was that posted the review, reach out personally. There's almost no harm. Don't threaten them. A lot of times people want me to contact them and send them a cease and desist or some nasty letter. There is a time and a place for that. Sometimes that's called for. You have employees who leave under less than favorable circumstances. Maybe they were terminated, and they were terminated for something pretty bad, and they have an axe to grind, and they go on, they post some negative review. That's usually what it is. It's former employees. It could be a patient, but it could be a former employee acting like a patient, or getting somebody else to put someone up to this. And sometimes you need to threaten them. There may be times too where you have anonymous reviews. So what happens if we let's go to, because I got a few minutes left. Let's go to a situation where you have an anonymous review. So let's say you're a pediatrician, you receive a negative anonymous review online, and how do you deal with that? How do you deal with the anonymous review? Well, you can go to the review host, whether it's Google Reviews or Yelp or someone else, and tell them, look, this is it's an anonymous review. I don't think it was actually a patient of mine. There's no way for me to verify any information because of the anonymity of the post. That has been legally challenged, and generally what the courts say is that, back to the founding of our country, when the Federalist Papers were being written, they were written under pseudonyms, and people have a right to state their opinions and not be unmasked or disclosed when they're stating their opinions online. Now you have this question of, well, what if you have online reviews? It's false, it's provably false. How do you demonstrate that? Well, I will tell you that the two ways that I'm aware of to deal with that situation, I had this with a client a few years ago, we did have some success, is if you want to unmask the person, you have to generally do it through a court action. You get a court order or a subpoena. You have to sue that person. You sue them as a Jane or a John Doe defendant. Now, this could have changed since I've done this, but this is how we would do it when I've done it. And I've done this a couple times. Again, one when we already get court ordered and have some success. You sue as a Jane or a John Doe defendant. You sue, that's the defendant, because you don't know the name. You may add the platform as an interested party and name them as a defendant, if it's Twitter or if it's Yelp or Facebook or another one. And then you file your lawsuit. There's a number of claims you can bring. If there's repeated negative posts, depending upon the content, if these are threatening, sometimes you get people that'll go on over and over. They'll even create multiple pseudonyms and go on and create these negative reviews. You can sue that person. Potentially, you may have a cause of action under cyber stalking or cyberbullying statutes. Florida has one that says basically 2 or more contacts with somebody online and using certain threatening words, phrases, etc., gives rise to a cyberbullying claim. Obviously, there's a potential defamation claim that's available. So and sometimes, depending on how your information is used, you may have something akin to a trademark or some type of intellectual property claim, or something under the Lanham Act. If somebody has taken your business and used it and presented it in a false light, you file your action. You then seek a court order. You could try it through a subpoena or through a discovery request, but normally you have to get a court order in order for it to be enforceable. Get a court order that requires the platform to disclose the personal information about the person on the post. Some forums will fight back more than others. You have to deal with that on a case-by-case basis. But if you're able to get information if you're able to get further information on the post, if it was obviously a fake account, and everything about the account is fake and there's no information traced back to somebody, then you can potentially get a court takedown order to remove that post. If it's not a fake account and you get real information, like what happened to us a few years ago, maybe it's enough under cyber stalking. In one case that I was involved in, we actually had the state's attorney's office, because of the threats and some of the other information in the post, pursue this, and the state's attorney went after criminal action, was actually successful in a criminal action against that individual. The posts were taken down and everything was resolved. It depends how motivated you are, depends how negative the other side is. A lot of information to think about here. Don't know if we've had any questions. I covered a lot of material that I wanted to cover. Obviously, as we look forward, we're looking at future innovations. AI is the big issue here. Deep fakes, potential for misinformation, potential to get the crowd, the general public, in an uproar about health concerns, especially following COVID. That's still fresh in everybody's mind. Best practices. What do I recommend? Well, it should be obvious from the content of what we discussed today. Professionalism is key. Bedside manner, protecting patient privacy through your own behavior, making sure you don't disclose private personal information online of anybody you're working with. Trying as much as possible to separate your personal and your professional personas online. For businesses and institutions, you certainly want to have a social media policy. You certainly want to have employees recognize that the business's social media accounts are assets of the business, even if they have login credentials or access to those accounts, which many businesses do. You need to have something that requires those employees to give you that information back, so you don't have to set up new accounts if somebody leaves and they refuse to turn over the information. I've had that happen. So I'm very adamant, and in fact, for some of the nonprofit groups that I'm involved with, we also have that same policy because we had that before. So I give them that policy, or I write the policy for them, and everybody who has access to online accounts acknowledges that in the policy, so we can get that stuff back. You want to continue to stay informed, participating or attending webinars. I know some of you, maybe you're on lunch, you have this in the background, but you learn about the FTC rules. When you have questions, reach out to somebody, contact you. I have clients that regularly contact me on these issues that have questions. We talk through them. You want to make sure that you're not violating some new rule or regulation because of the pace and the speed at which rules and laws continue to change in this environment. And we talk about reflective practice. Really, what this means to me, you'll see this term, it's really thinking. And one last thought I will leave everybody with is one of the complaints that I have as we get busier and things get more efficient in law, and I think this happens to other professionals, is we rarely have time to just stop and think about things. And the types of issues that we talked about today are issues that, in my view, require you to stop, slow down, and think strategically and think about the best approach oftentimes. And I encourage folks to do that for themselves, especially if you're about to post something, given the widespread nature of the communication and the immediacy and the permanency and the damage that you can do if you post something online that you regret. Think long and hard about anything you're going to put in a public forum, and when in doubt, sit on top of it. Don't post it. Let somebody else look at it, think through, walk through it, and then decide the proper way. Don't rush into this stuff. A lot of potential benefits, obviously, to social media, but a lot of potential risks that come with that, and things that can do long-term damage to your reputation. And we're trying to keep up and keep pace with all that. So I hope this was helpful for you. I hope it was informative. We close out today. My contact information is on the screen. If you have any follow-up questions afterwards, if you have any scenarios that we didn't run through, but you want to run through privately, anything that's come about, I've seen a lot of different crazy stuff, and I'm happy to talk through it with you. Have a great rest of your day, and thanks for being with us today.